look at this book. This book is all about Illinois DUIs. How am I supposed to explain this in a 60-second video? I couldn't explain this in 60 hours. You guys had tons of comments, tons of views on last week's video about refusing the breathalyzer test here in Illinois. I appreciate all the comments, but they need to go through one by one. If you really want an explanation, it's not going to be done in a TikTok comment. I'm going to answer your questions right now. By far, the number one thing you guys said is don't drink and drive. Let me tell you, I agree with you. Absolutely. I've had family members who were seriously hurt when they were hit by a DUI driver. I've had clients who've had their entire lives changed because of the poor decision to drink and drive. I absolutely agree with you. But I also believe that good people sometimes make a bad decision, and they're entitled to know their rights, and they're entitled to a defense in court. Also, you guys made tons of comments about other states. You're telling me how it works in New York and California and Missouri and Michigan and all these other places. I appreciate those comments, but this only applies to the state of Illinois. The laws are different in every single state, and I don't want someone to be confused. I don't want them to read your comment about New York and think that it's true here for Illinois. And so that's why I'm making this video, to fully answer the questions as they relate to Illinois DUIs. Another comment you guys all had is that, well, yeah, but if I refuse the breathalyzer, isn't my license just going to get suspended? And you're right. And in fact, it'll probably be suspended for longer if you refuse the breathalyzer. That's how it works here in Illinois. However, there are two major benefits of refusing it. And that is, first of all, the chances of us overturning that suspension are far more likely if you've refused the breathalyzer. Let's think of it like this. When the government takes something away from you, and that is what's happening when the Secretary of State suspends your driver's license, they take away your privilege to drive. When that happens, you are entitled to a hearing or an appeal of that. And it is far more likely that we will win that hearing if you've refused the breathalyzer. The second major benefit has to do with the outcome to the DUI charge itself. See, here in Illinois and really in all states, if you blow a .08 or above, then you are deemed to be intoxicated. There is no arguing about, well, you were just tired, or your eyes are red from working late, or, you maybe took a bad step when you were doing those sobriety tests because there was a rock on the ground. None of those things get argued about. The fact that you took the breathalyzer and were over the limit proves to the court by law that you were intoxicated. You could be stone sober. You could be a gymnast. You could be a race car driver finishing the Indy 500, and you are perfectly sober, but that test shows you're .08 or above, you are deemed to be intoxicated. If you refuse the breathalyzer, well, then now we get to argue these things. Now we get to tell your story. My favorite comment is from BLXI. He says, so you just say no? Then you have to go to court, keep quiet, and they prove it in court. Yes, that's exactly right. That's my favorite comment, because that is exactly what any criminal defense attorney is going to tell you about any criminal offense that you may be investigated for. Is just keep quiet and deal with it in court. Andrew Marchillo says, get on top of your car and do a backflip. This should indeed prove your sobriety. I love this. He's right. If you can do that, hey, go ahead and try to pull it off. Otherwise, I would say you should refuse the Stanford sobriety tests. So, Tommy Taco and Lovey Dovey Player and many of you guys had questions about blood. In other words, if you refuse the breathalyzer like I suggested, aren't they just going to go ahead and draw your blood? I understand why you're asking that. That is possible, and that is what may happen where you live. However, here in Illinois, and specifically in the Chicagoland area, it is pretty rare for them to take a blood draw as a result of a DUI arrest. All right, so let's break this down. You get arrested for a DUI, they told you to do the breathalyzer, and you refused. So now the police are angry at you, right? And they're going to take you to the hospital, or they're going to have a phlebotomist come to the station in order to take your blood. Well, guess what? You can refuse that too. It's the exact same as refusing a breathalyzer. As a matter of fact, you can refuse a urine test as well. There's no additional penalties for that. This is at the request of law enforcement, and you're refusing to do it. You have that right. Now, things get different if a judge signs a warrant. Oftentimes, at least here in Illinois, if it's a serious case, there's an accident with real bad injuries, or you're a repeat offender and you're going to be charged with a felony DUI, then they absolutely can and will go wake a judge up in the middle of the night, tell him what happened, and get a signed warrant to get your blood. In that case, it's not at the request of law enforcement. It is a court order warrant to get your blood. And you should not refuse. If you do, you would be charged with a felony, obstructing justice, because you're obstructing the judge, not just the police officer. Otherwise, they will not get your blood, and you can absolutely refuse it short of a warrant. DH89A asks an interesting question. He says, but what if I haven't been drinking? It's a really good question. I had a friend text me this after watching the video as well. And in that scenario, I would say, sure. If you want to go ahead and do the breathalyzer and prove that you are 0.0000, then go ahead. But if you're at all unsure, you may want to reconsider. Additionally, even if I was stopped, not having had a single drink, I would not perform the standard field sobriety test personally. An officer is going to see what he wants to see when it comes to the field sobriety tests. So the grass man says that when you sign the papers for your driver's license, you agree to take the standard field sobriety tests. Sorry, grass man, that is not true. What he's talking about here is implied consent. And it is true that when the Secretary of State gives you your driver's license, it is implied that you will consent to a blood, breath, or urine test. However, that is not true when it comes to alcohol and standard field sobriety tests. You are allowed to refuse them without penalty. So Anthony21 asks an interesting question. He says, so what should I say to the cop when he asks if you have had anything to drink? Do I lie or do I say nothing at all? Well, I'm never going to tell you to lie to the police. That's a bad idea. But you do have the constitutional right to remain silent. And that's a right that you should exercise. Now, you may upset the police officer a little bit, and people are hesitant to remain silent because, well, they're interacting with a person of authority. But keep in mind, you are getting arrested anyways. So the better bet is to not give them evidence that can be used against you in court. So how do you go about doing this? Well, you can simply say, I'm not going to answer any questions without my lawyer present.
I plead the fifth.
Buford T. Justice has a great comment, and this is something that everyone watching can learn from. He says that he had one beer and he passed all the field sobriety tests, but they still made him blow, as they often will, and he blew a .04. That is 1/2 of the legal limit. And he told me that they can still take him to jail because they think that he is impaired. And he is absolutely right. You would be shocked how many times people are still arrested when they're below the legal limit. It is not at all required that you blow a .08 or above to be arrested. And that is something that many people overlook, and that is one of the fundamental reasons that I will often tell people that they should avoid the breathalyzer in the first place. So Tim Kessler says that this advice is not applicable to CDL holders. It is. In Illinois, this advice is absolutely applicable to CDL holders. We represent hundreds of CDL drivers every year, and the same holds true for them. Yes, you're facing a suspension, and that's really difficult, especially as a CDL holder. But in the long run, both when it comes to the ability to overturn that suspension, as well as the ultimate outcome to your case, which is really important if you're a CDL holder, it is better to refuse that breathalyzer in almost every scenario. I love Luke Benkley's comment here. He says that I assume that this advice is only if you've had multiple drinks and are at risk of being above .08. Yes and no, right? Like if you know exactly what your BAC is, well then sure, you know whether or not to do the test. But you don't. You have no idea what your BAC is if you've even had one drink of alcohol. So it's better in that scenario to play safe and not find out with an officer standing across from you. You're going to be better in the long run if that remains a mystery rather than giving them that result right in front of you. And you would be surprised how many people say that they were in no way intoxicated and were no way over the legal limit, yet they have a breathalyzer that says otherwise. So let's take an assessment of where we're at. You've been arrested for a DUI, you've refused a breathalyzer, You've even refused a blood test if they've threatened you with that, short of a warrant. And so now, how are they ever going to convict you of DUI? Well, they certainly still can. But what they have to do is they have to show that you were too intoxicated to safely operate that motor vehicle. They have no chemical tests, no blood, urine, or breath tests to submit to the court. So then they're stuck in court relying on how did you drive? How did you act? How did you perform on field sobriety tests if you made the mistake of doing those? And those are things that can be argued over in court. In fact, Gonzo says it's okay. They have the driving, the slurred speech, and the stumbling, right? Plus, there is a police car video nowadays. And Gonzo is absolutely correct. You can still be convicted of a DUI despite refusing these things. But it's harder for them to do. They must prove this to a judge or a jury based on your performance on all the other things that you did or didn't do. And so that's why, big picture, most DUI attorneys are going to tell you to refuse it because you're giving them less ammo, less evidence for them to prove their case that you were too intoxicated to safely operate the motor vehicle beyond a reasonable doubt.